Very good morning, ladies and gentlemen, and a warm welcome to this Quadrant Chambers Legal Breakfast Forum. Very glad to see so many of you are starting the first day of the exciting London International Shipping Week with us this morning. After a difficult and unusual 18 months, it is particularly good not only to be able to be joined by so many virtual guests, but also to be here once again in the library at Quadrant Chambers with a live audience. Thank you very much for coming. Welcome back. The Breakfast Forum is the first of three that Quadrant will be giving in London International Shipping Week, discussing current hot topics in shipping and shipping law. Today we're looking at charter parties. Tomorrow at the same time we're going to be discussing the impact of new technologies on cargo claims. And on Thursday, also at the same time, looking at the special issues facing the container ship industry. I hope you can join us for those as well. The routine negotiation and conclusion of charter takes place against the backdrop of an ever-changing world, with its new problems, its new dilemmas, its new crises. This morning our panel will be looking at four very current topics: hacking and cybersecurity, especially in the context of an increasingly computerized shipping industry, with fully autonomous cargo ships just around the corner. See Nippon Yusen's announcement last week. Sanctions and sanctions breaking. The ever-increasing use of sanctions and their scope, and the long arm of OFAC from the US pose special problems for shipping. And shipping is one of the main ways in which sanctions are sought to be evaded. Climate change, very much to the fore with the publication in August of the IPCC report, with its Code Red for humanity, and the control of emissions and the need for clean energy solutions, posing huge future demands on modern ships to go green, or at least go greener. And last but not least, the dreaded coronavirus and COVID-19, which none of us last March, I think, would have suspected would last so long, and which have affected our world so much. And shipping, which crisscrosses the world and links countries with all sorts of states of infection and different variants, has been in the front line from day one. When these sorts of crises suddenly come up, often one looks expectantly to one's charter party and finds it lacking. There is usually a need to future-proof your charter party, and that is where BIMCO comes into its own. Like Argus with its many eyes, it is continually investigating and drawing up new model clauses for new problems and future issues facing the shipping industry. This morning, our panellists are going to look at four such model clauses. Let me introduce them. Gemma Morgan from Quadrant Chambers, described in the directories as having a laser-like focus, seeing the big picture and able to set out the approach in a clear and precise way. Well, ladies and gentlemen, you'll be able to be your own judges of that. Is going to consider the BIMCO Cybersecurity Clause 2019 and looking at the tongue twister of cybersecurity incidents. Note that there will be discussion of cybersecurity problems in our container ship forum on Thursday. I, and I'm not going to give any directory entries about myself, I'm going to consider the BIMCO AIS switch-off clause, hot off the press, 2021. Next, we are delighted and honoured to be joined by Andrew Preston, long-time head of shipping at &Co, and one of the founding partners of Preston Turnbull, described in the directories as probably the best lawyer in London for head-on-the-block advice. A nice relaxed morning this morning. He's going to take us through the intricacies of the BIMCO Just-in-Time Arrival Clause 2021, drawn up in the context of the IMO's attempt and strategy to comply with the 2015 Paris Agreement on reduction of emissions. And last, Peter Stevenson, described in the directories also as having a razor-sharp, incredibly impressive ability to navigate the complex issues and to get to the heart of any problem. Again, you can test that for yourselves. Is going to be discussing the scope and impact of the BIMCO COVID-19 Crew Change Clause 2020. And even as I speak, BIMCO is hard at work on a revision of its infectious and contagious diseases clause in the light of the COVID experience. We're going to have plenty of time at the end for question and answer session, which Gemma is kindly agreed to chair. So please bombard her with questions and comments using the functionality on Zoom, and we will do our best to answer them. So over to you, Gemma. Does the BIMCO Cybersecurity Clause 2019 work in dealing with cybersecurity incidents?
Well, let's have a look. Thank you, Simon. So what is the problem? Well, both the threat and the potential consequences of cybersecurity breaches within the maritime industry are, I think, now well known. There have been many cybersecurity incidents reported in the press in recent years, but even then I think it's fair to say that the majority of them are kept out of the headlines, mostly for fear of reputational impact. It's not just the cost to ship owners and disruption to cargo interests, or even potential threats to life and the environment, that have driven the issue to the top of the agenda. As I'm sure you're aware, from the 1st of January this year, IMO Resolution MSC 42898 requires cyber risk management to be part of a vessel's safety management system. So the long-standing obligation upon ship owners to assess all identified risks now expressly includes cyber risks. And I think that's left a lot of people in the industry playing catch-up, although the introduction of the new rules has been known for some time. There are a variety of potential cybersecurity threats to shipping company and their vessels. There's ransomware attacks, malware attacks, phishing, data breaches, the nightmare scenario of loss of control of the vessel as well. But what they mostly have in common is 1, disruption and cost to the ship owner, 2, disruption and cost to chartering and cargo interests, and 3, the potential for large claims being brought against ship owners by charterers and cargo interests for the consequences of any disruption to the ship during its voyage. Whilst there are obviously many technical challenges for owners and managers around cyber incidents, it's that latter point that the clause I'm going to discuss tries to deal with. Namely, where does contractual risk lie between owners and charterers in the event of a cyber incident affecting the voyage? BIMCO's cybersecurity clause seeks to answer that question by imposing a positive obligation on both parties to ensure the security of their own systems. So let's have a look. It starts, first of all, with a series of definitions, just 3, cybersecurity incident, cybersecurity being what you would expect. Just worth noting, I think, in digital environment, there's a reference there to information technology, which we're probably all familiar with, but also operational technology. Now, if you're uneducated technologically as I am, you may not know exactly what that means. What that involves is systems which are used to monitor and control machinery effectively. So, for example, a propulsion system. So in the context of shipping, operational technology is going to be very important because obviously there is potentially an awful lot of that on board any vessel. So getting into the meat of it, Subclause A requires each party to implement appropriate cybersecurity measures and to use reasonable endeavours to maintain its security, and to have in place appropriate plans and procedures in the event that an incident and a breach of cyber defences occurs. Now, the question, of course, is going to be what constitutes appropriate measures and plans. In its explanatory notes, BIMCO envisages that what will be appropriate will depend upon the size of the company and the nature of its business. But I have to say, reading the clause and construing it in its context, I don't see that as being the obvious meaning of the word at all. On the contrary, if you look at the clause, the things which have to be appropriate are the cybersecurity measures and systems designed to prevent a cybersecurity incident. Therefore, one would have thought that the proper construction of appropriate is that it relates to the ability of the measures to prevent such an incident, no more and no less. Now, for owners and operators, a great deal of guidance is already available about what is required for compliance with the IMO rules, and I suggest that compliance with those rules will likely go a long way towards satisfying the requirement of appropriateness. However, for charterers, there is currently far less guidance and far less external pressure for them to consider their measures and systems. So I think the point about this clause is that it imposes an obligation upon both parties. And that's, I think, something that charterers are going to have to think carefully about before agreeing to include this clause in their charter party. Then subclause B is an interesting one because it requires both parties to ensure that any third-party contractors or agents providing services under the charter party also have appropriate security measures in place. So both owners and charterers must ensure that their shipbrokers, agents, crew management companies, etc. have properly robust cybersecurity measures in place. Now, it seems to me that's a potentially very onerous obligation. Reasonable endeavours is not a light touch requirement. So, for example, will it be enough to simply ask to see the relevant subcontractor or agent's cybersecurity policy? I think arguably no. What the clause requires is that the endeavours undertaken are required to ensure the status of the third party's cyber defences, which to my mind certainly implies active engagement with what the third party has in place, so that anyone acting on your behalf has robust measures the same way that you are. So I think that's a potentially quite onerous obligation in what is potentially what is actually just a short sentence. Then we have subclause C. So this goes on to deal with the situation where a cybersecurity incident has in fact occurred. Each party has to notify the other within 12 hours, and that's no matter how minor the incident. So it could be a small data breach, but you still have to notify the other party. And then you also have to take all reasonably necessary steps to resolve or mitigate the incident. One would hope that would be being done anyway, but it's there in black and white. Now, in terms of what is reasonably necessary to fulfil the obligation to mitigate, one would expect that to depend upon the type of threat and indeed the value of any potential loss that could be caused by the threat. And then finally, subclause D is potentially the crucial one, I think, for this clause. What it provides for is a default $100,000 limit on liability for breach of the clause by either party, although the parties can agree a different figure. And so there's a blank box for the figure, but if left blank, then $100,000 applies. Now, this subclause will, I think, be the driver for ship owners to try to include this clause in their charter parties, where, of course, they have the bargaining power to do so. Now, it does have a gross negligence or willful misconduct exception, and for a large claim, I would certainly expect a lot of litigation to be generated with parties trying to break limits if the limit is far below the value of the loss. So, stepping back, answering Simon's question, is this clause a useful addition to any charter party? Well, it does have advantages. It's straightforward, and subject to the level of the limit on liability, it is even-handed. It applies to both parties. Its broad language means that it's suitable for inclusion in different types of charter party, so that it can readily be used back-to-back to ensure protection up and down the chain. It also gives express protection for both owners and charterers in the event that their counterparty does not have adequate cyber security. Now, given that there is currently, I think fair to say, a marked variety in levels of diligence between different actors in the industry in terms of seeking to protect their own cyber interests, I think this must be welcome, because when you have this clause and it requires protection for both parties, one would think it might encourage the other party to think about their cyber security in more detail. Let's wait and see. But does it add substantively to the usual allocation of responsibility in charter parties in the event of a cybersecurity incident affecting cargo or chartering interests? For example, the obligations of seaworthiness upon owners, or the obligation to take proper care of cargo under the Hague-Visby regime if that's incorporated into a voyage charter. Well, I think probably not significantly. The actual standard of care to be expected of ship owners certainly will be broadly the same. Breach of the IMO rules is going to be a source of attack for charterers whose goods are damaged or business affected by a lapse in cybersecurity, whether under this clause or without this clause under the usual regime. But as I've said, what the clause does have is the significant carrot for owners, the ability to limit in advance their liability for cybersecurity breaches. And I think that alone will considerably improve a ship owner's ability to get insurance for cyber risks. Which brings me finally to one important issue which is not currently covered by the clause. As you can see, it does not impose a requirement on the parties to obtain insurance for cyber risks. So could that become the norm in the future? Well, BIMCO did consider including the insurance obligation, but decided that such a requirement now would be premature. Because at the moment, I think it's fair to say that the cyber insurance market in the marine sector is still in its relative infancy. Many underwriters have a low level of appetite for cyber risks and often look to either exclude them or to impose stringent requirements as a condition precedent to cover. and certainly talking to contacts in the industry, the level of cover currently available will not cover potentially very large losses, which could fall to an owner in the event of both business interruption and very high value cargo claims. And you add to that that premiums for this type of cover are also on the rise. So certainly I think while big owners and operators are pressing ahead and trying to get and are able to get as much cover as they can, many smaller players are not in a position where they can currently get effective cover for cybersecurity breaches at a realistic price. Ultimately, I predict that a mutual requirement for cybersecurity insurance will become the norm and will ultimately make its way into this or a comparable standard form clause in much the same way that, for example, specialist K&R cover developed to become standard following the increase in piracy. So on insurance, I would say watch this space and perhaps come back next year. I will hand over to Simon.
Thank you very much, Gemma. And you can see there the impact of new BIMCO clauses on current problems. I'm going to be talking about the BIMCO AIS switch-off clause for time and voyage Charterparties 2021, literally hot off the blocks, only a couple of months old. As we all know, AIS is a device to aid navigational safety, and it transmits information about a ship, including its identity and position. It's mandatory under SOLAS, and it's not allowed to be switched off or disabled at any time when afloat or at anchor, save for very specific safety and security reasons permitted by the Convention. So it's not a sanctions tool, and I said I was going to be talking about sanctions. And it's not a policing device. But plainly, it's very awkward if you are intending to violate or evade sanctions, because you can track yourself, or somebody else can track yourself very, very easily. And so AIS manipulation, spoofing as it's called, has become a hallmark of sanctions breaking, and it's very, very common indeed in illicit STS cargo operations. Strictly speaking, there should be no need for a clause, because SOLAS is SOLAS, and therefore you're not allowed to turn it off except when SOLAS says you may. So why do we have a clause? The answer in one word is OFAC. On the 14th of May 2020 last year, OFAC issued an advisory guidance to address illicit shipping and sanctions evasion practices. And I quote, "This was to provide guidance to," and then there follows an enormously long list of parties: ship owners, managers, operators, brokers, insurance companies, flag states, commodity traders, and others. And OFAC stressed the need for all of those people to address sanctions risks and to implement compliance controls, especially when operating in high-risk areas, in, for example, the Persian and Arabian Gulf. Number one on their list was deceptive shipping practices, and number one on the list in that list of deceptive shipping practices was disabling or manipulating the AIS of vessels. So spoofing to give oneself a different identity, or just turning it off so you disappear from sight. And the practice and control mechanisms which OFAC recommended included not only identifying vessels which you've dealt with in the last 2 years, which have AIS irregularities, but also adopting contractual language in the form of an AIS switch-off clause, allowing ship owners, charterers and operators to terminate work with any clients that demonstrate a pattern of multiple instances of AIS manipulation that is inconsistent with SOLAS. When OFAC speaks, the world trembles. The consequences of that advisory was immediately a rush by charterers to put in some ad hoc clauses to make it look as though they were complying with OFAC guidance. Those clauses were very blunt instruments. They gave charterers often, and still do, the right to terminate simply on the basis that the AIS transponder is not working. Pretty draconian. And that is why BIMCO became involved very, very quickly, because it said that one of the reasons for drafting a standard BIMCO clause has been to address the shortcomings of such ad hoc clauses and to try to balance matters up between owners and charterers a little more. So with commendable speed, BIMCO set up a working group with representatives of major owners and others in their usual way, and produced on the 16th of July 2021 its AIS switch-off clause for time and voyage Charterparties 2021. I'm going to talk about time and voyage Charterparties, but of course the clause will have an impact on demise Charterparties, because it's possible to rework the owner's sets of obligations in that context. But that perhaps is for another day. The clause oops, yes, the clause needs to be read with the snappily headed IMO revised guidelines for the onboard operational use of AIS, Resolution A1106/29. And you really need to read, therefore, the clause alongside that guideline, the set of guidelines. And the clause really falls into two parts, a set of obligations on the owners and a set of obligations on the charterers. Let's start with paragraph B, which deal with the owner's warranty. You see what it says, owners warrant for the 6 months prior to the arrival of the vessel and throughout the duration of the charter party, they will not knowingly operate the AIS other than in accordance with the guidelines. So let's note a number of salient features about that clause. Firstly, it is not only a future warranty about the due operation of AIS during the currency of the charter party which is about to be performed, but also it is historic. And there are two reasons for that. Charterers will want to avoid a ship or owners being sanctioned due to some past switch-off irregularity. You'll note the period is 6 months, that is, can be amended. You'll compare that with OFAC, which said you should look back for 2 years. 6 months has been picked according to the BIMCO explanatory notes based on the, I quote, the subcommittee's own experience of the time frame within which IAS switch-offs can be identified. I'm not necessarily sure that's right. I think you can find out AIS switch-offs a lot earlier than that, but that's what they've done. Secondly, OFAC guidelines. OFAC guidelines suggest that the history should be checked. So instantly, one now has, as part of any sanctions compliance programme of a prudent and well-run chartering organisation, the need to look back. Second salient feature, it's not just switch off, but all manipulation. You see the words manipulating, knowingly switching off or otherwise disabling, so spoofing will be covered. Thirdly, you have to show, or the owner's warranty is only that they will not knowingly turn it off or spoof it. So it's dealing only with deliberate breaches of SOLAS. Breakdowns are irrelevant. Signal losses due to bad reception are irrelevant. Accidental switch-offs, and they happen, are irrelevant. The negligent failure to turn it back on when you come out of, for example, a piracy zone, that will not be caught either. But notice that the purpose is irrelevant. So it's not dealing with sanctions. Whatever reason you deliberately turn off your AIS transponder for, it will give you a right to terminate. So if you turn it off, for example, because you're going to engage in some dodgy navigation, you're cutting a corner, a case I've had, and so they decide to go blank, so no one can see them cutting the corner, that will give an immediate right of termination. What is permitted under SOLAS? SOLAS requires the continual operation of AIS unless it compromises the safety or security of the ship or where security incidents are imminent. And that's set out in the IMO guidelines. The classic example is going dark in a piracy area. It's actually quite difficult to think of any other security incidents. Fourth salient feature about that obligation, so prima facie there's a pretty heavy burden on the charterer because it has to prove knowingly operated the AIS in an improper way. Possibly to help the charterer in that regard, you'll see that in C and D, the charterers have a right where they reasonably believe that owners are in breach of subclause B, and you've got to have a very good reason for turning off AIS, so as soon as AIS is turned off, charterers will usually have a right to instantly request information. And the owners have to provide an explanation within 72 hours. You'll note that there's no sanction if the owners decide not to provide the information. You can't terminate for not providing the information. You'll simply be in breach. And so the explanatory notes say that there's no right to terminate, and if the owners do not comply with the charter's request, then the charterers may be able to infer that there's a good reason for that, but it's up to them whether they decide to exercise the right of termination. It would be quite a brave charterer to do that. I've considered variants of this clause, whether you should beef that up by saying if they don't provide an explanation within 72 hours, then charterers have a right to provide, to request they provide a further explanation within 24 hours, or there will be a right to terminate, because the consequences for charterers are potentially very disastrous. So you'll also notice that a single switch off under this clause will give the right to terminate. OFAC looked at a pattern of AIS manipulation. This clause does not. And the reason for that is, as given by the explanatory notes, this is considered to be fair and balanced because, and I quote, only malicious switch-offs are covered under the warranty, and one intentional switch-off could result in owners becoming designated and exposing the charterers to potential enforcement actions. The consequences of being sanctioned are so severe that there should be the contractual right for the innocent party to remove itself from such a transaction. There's also a much more practical reason. It's much easier to deal with one single unexplained incident that the owners can't explain. Having to show a pattern, what is a pattern? 2, 3, 4, manipulation, slightly broken signal. So BIMCO have gone for an easy solution. That's the owner's set of obligations. Let's look at the charterer's obligations. Charterers warrant that they will not request the owners to operate the vessel in breach of SOLAS. Well, in one sense, that really is not something which you need to specify, because under time charter parties, an owner could say, that's not an order you're entitled to give me. Under a voyage charter party, that's certainly not an order that a charter would be able to give the owners. So it seems rather artificial, I think, to have a clause dealing with that, but plainly, as BIMCO wanted to balance it up, they have to put something in on the charterer side of the equation. If a charterer is stupid enough to ask the owners to turn the AIS off, then in F1, the right of the owners is to reject the request or terminate the charter party. So only a lunatic charterer would say, would you mind turning your AIS off contrary to SOLAS, please? So that's why I think that's rather a window dressing clause. But I think E2 is very important. As OFAC pointed out, most sanctions breaking happens with STS transfers. So you're loading cargo from one vessel into another, and the AIS, the dodgy AIS history may conceal the origin of the cargo which you're loading ship to ship. You can't do it in a terminal, but you can do it ship to ship. And so charterers warrant that they will not give orders to conduct an STS transfer with a vessel whose AIS has not been operated in accordance with the guidelines throughout the last 6 months prior to the orders. And that looks very good, doesn't it? Except, how does an owner, his right is to refuse to conduct the STS and request new orders, CF2, how does an owner deal with that? The E2 is talking about a vessel whose AIS has not been operated in accordance with SOLAS. How on earth does an owner know? The owner may know that the AIS history of the vessel over the last 6 months, if it checks, is irregular. There may be an incident of 2 days turned off. But how does he know that it hasn't been turned off for a good reason, because of a breakdown or something like that? So take this example. The owner checks the AIS history and finds 2 incidents in the last 6 months. He's very suspicious. There's no right to request information. There's no right to compel the charterers to find out. Does the owner take the risk of refusing to comply with the orders and therefore being in breach of charter party? What's the consequence in terms of on-hire and off-hire under a time charter party? Is time lost, should that count as demurrage? None of those problems are really dealt with by E2. And so I would suggest that that needs to be looked at, and that there needs to be a variation of this clause so that owners are entitled to refuse to comply with the orders where the owners are ordered to load or do an STS operation with a vessel whose AIS history for the past 6 months is incomplete and shows instances of AIS being switched off or not operated. Then it is for the charterers to bear that risk, because the charterers are the ones who are organising the STS. The charterers are the people best placed to be able to organise the proper investigation of the STS history. And while they are doing so, then the vessel should remain on hire, that should be expressly stated, or if you have a voyage charter party, there should be a right to claim demurrage. And I think that would be a very useful revision of that clause. So, ladies and gentlemen, that's the AIS switch-off clause. The purpose of the clause, BIMCO states, is to ensure that a fair balance of the rights and responsibilities between owners and charterers in preventing AIS manipulation to evade sanctions. I think it's a very good start. But I think on the charterer's side, that E2 does need looking at. So with that, I conclude on AIS switch-off clauses, and I now hand over to Andrew Preston, who's going to talk about just-in-time clauses for voyage charter parties. Andy.
Well, good morning. I get to talk about the green shipping clause today. Just-in-time clauses for voyage charter parties has no relevance to time or bareboat charters. It is simply a concept that has been brought in as part of the suite of legislation and guidelines on green shipping. The backstory is quite important, where just-in-time clauses are not remotely new within other sectors. They've been used in manufacturing for years and years and years. They are a new concept in shipping, and they really stem out of our obligations set out in the Paris Agreement in 2015, where everybody recognised the need to reduce greenhouse gas emissions, and every industry had to play their part within the attempts to reduce greenhouse emissions. The shipping industry, through the IMO in April 2018, set out the mission statement. That mission statement was reducing emissions by 50% by 2050, a bold and challenging target, and the legislation and the directives that are coming through are all aimed to achieve that. The just-in-time clauses are a very, very minor part of a much, much bigger initiative, and they should be seen as such. So at the risk of teaching everyone to suck eggs, where are we at the moment? BIMCO, when they're drafting this clause, nicely described it as the hurry and wait system of voyage charter parties, where on an approach voyage, once the charter is fixed, the owner will race to the load port to make sure he hits the laycan. And if he fails to hit the laycan, then of course the charterer can cancel without further issue and possibly claim damages. The vessel may then sit for a considerable time, earning demurrage, and will then, following loading, will then proceed with utmost dispatch to the discharge port, where she again may wait for a considerable time. On any view, that is a fuel inefficient way of running a business, where the owner may be consuming far too much fuel to make sure it gets to the port on time so that it's not in breach of the laycan provisions. It may then proceed with utmost dispatch, as it's contractually obliged so to do, to the discharge port, where again that is a fuel inefficient method of travel if one has to sit outside a port for several days, weeks or months waiting to discharge. And the whole concept of just-in-time envisages a grown-up discussion between all the stakeholders within the industry as to when the vessel will realistically get into berth, when she will realistically get into the berth at the discharge port, and tailor the speed of the voyage accordingly. To achieve that, BIMCO have had to not slaughter a few sacred cows of voyage charter law, but they certainly had to push them to one side a little bit to make this clause work. There's been a fair amount of research done as to whether just-in-time really can work within the shipping context. And one survey in Rotterdam did an analysis of Maersk and MISC vessels going into the port of Rotterdam, and they worked out that if a just-in-time system had been operating, so instead of racing to the port, it slowed the speed down to make sure it arrived just in time, there were 8 to 9% fuel savings, which over the course of the whole industry we're reducing fuel by 8 to 9%. That is, on any view, a good thing. But how have they done it, and does it work in practice? Well, there are 5 parts to the clause. The first one is what you might describe as the fluffy bit, where it recognises that it's only ever going to work if there's a constant dialogue between the owners, the charterers and all the other stakeholders, the port agents, the port itself. Unless there's an information flow about when the cargo is ready, when the vessel could go into berth, it never gets off the ground. And unlike Gemma's clause, which talked about reasonable endeavours, the opening words are, the owners and the charterers shall use their best endeavours to obtain and share information. It is a high obligation when this clause is written into the charters. It's not just do your best, there is a full transparent dialogue about the port delays, about port congestion, and so that informed decisions can be made about whether to enact the following provisions within the clause. You then turn to B, which really sets out the gateway to how this clause works. And the opening words are notwithstanding any other clause in this charter. So it trumps all the other conflicting clauses, the charterer shall be entitled to request the owners in writing to adjust the vessel's speed to meet a specified time of arrival. It's a charterer's election. It's not an owner's, it's a charterer's election to decide whether to ask the vessel to proceed at a slower speed. And because it's a charterer's obligation, many of the other clauses that follow deal with the effects of that on owners. Does an owner have to follow an instruction from the charterers? The answer is no. It's always subject to the owner's consent, which shall not be unreasonably withheld. Now, whenever lawyers see the word unreasonably, one can see the scope for argument and the scope of what is reasonable. Is it an objective test? Is it a subjective test? Are we down to the Braganza principles of the owner shall not refuse and act arbitrarily and capriciously? We can suspect if the market conditions are right and there's a fight over this, then people will look very closely about the owner's actions and whether the owner should or shouldn't have consented. And then the final bit of clause B tries to deal with the situation that, of course, if a charterer asks a vessel to slow down on the approach voyage, she may well miss her original laycan. And that is an inevitable consequence of an order to slow steam. And so it makes it clear that the original laycan is adjusted so that if a vessel proceeds slowly to get to the load port and she misses the original laycan, there is no right to cancel. So that's the gateway. What happens when the charterers do enact their right and ask the vessel to slow steam and the owners accept? Well, that's what C tries to deal with. It's the overarching point about the clause is that it's not intended to shorten the voyage, it's to smooth the bumps out along the way. So it is trying to find a mechanism to compensate an owner who may have slow steamed and therefore not got to the port earlier, has lost the right to claim demurrage and instead has chosen to slow steam to shorten the time at the port but elongate his voyage. And it looks at the concept between estimated time of arrival and actual time of arrival. And one doesn't have to be a rocket scientist to figure that out, that if on the usual contracted speed it would arrive on a certain given date, tender NOR and go on to lay time and then demurrage, if the clause is enacted, one looks at when she actually did arrive and then the delta between those two calculations forms the subject matter of the debate. As to how one allocates the cost saving or the economic impact of the clause, BIMCO have essentially thrown it back to the market and said, figure it out for yourselves. It gives two options. The first option is for the parties up front to agree a fixed sum of money that would compensate the owner for slow steaming should the clause be enacted. And I leave it to others to consider whether on a short, tight negotiation turnaround, whether the brokers are going to sit and negotiate a figure at that point. So I think inevitably we are going to be in the default setting, which would be as otherwise agreed by the parties, which shall take into account the saving in fuels by the owners and shall be payable by the charterers to the owners prior to completion of the final discharge. So what it envisages is if the clause has been enacted and there is a time saving approaching the load port, or if there is no racing to the discharge port and there is a slow steaming again, it is incumbent upon the parties to then agree a mechanism and a compensation package. And one would hope that mature owners and charterers would find a way of so doing. One can see that others may not, and you would be in dispute. One of the earlier versions of the clause had an expert determination provision, but that was deleted and we are down to the resolution procedure within the charter itself to determine how the compensation will be arrived at. The explanatory notes and the clause itself merely suggest that one takes into account the fuel saving. So where there is obviously less fuel that is being consumed, then the saving to the owners should be borne in mind when talking about the compensation payable by a charterer for the slow steaming. But for the clause to work, you also need to move to one side some of the other obligations that appear throughout a charter, and quite rightly so. There is an utmost dispatch obligation upon an owner to proceed on the laden voyage as quickly as reasonable. And so the clause has to make it clear that where the owners have complied with the Charter's request not to proceed quickly but to slow steam, there is no breach of the utmost dispatch obligations. And then the final clause recognises that voyage charters are simply one of a number of documents around the international carriage of goods, whether you're talking about underlying sales contracts, FOB, CIF, whether you're looking at bills of lading, way bills, or any other contractual documents that, as a suite, explain why cargo is moving from one place to another. And it recognises that all an owner has is his contract with the voyage charterer. If the voyage charterer has asked him to proceed slowly so he may not arrive at the load port or the discharge port as quickly as otherwise he might, then it's a recognition that unless the voyage charterer has ensured that all the other contracts within the chain, whether they be the sale contracts, the bills of lading, are similarly aligned to the just-in-time principles, then there may well be a breach by owners, and there is a full indemnity from the charterers as a consequence. So it's starting to get some time charter principles of indemnifying for employment orders. And that's the clause in a nutshell, 5 parts of it, pushing to one side some of the principles we know, and it is a sensible clause on many, many levels. But will the market ever adopt it? I did an extremely unscientific straw poll of a few operators before doing this talk, and they may be outliers, but the universal reaction at this point in time was, we are not using this clause, but we might. And I think the reason for people's reluctance at this stage to put it into the voyage charters is simply that it's in a strange economic environment we live in at the moment. The studies that are being done, whether it be looking at extremely sophisticated operators in the liner trade going into an extremely sophisticated port, were a theoretical analysis to get a cost saving. Articles have been written about the delay times in Long Beach and how a just-in-time programme might help in that environment. But no one's looked at the 2 or 3 month delays waiting to load grain out of San Lorenzo, or the 6-month delays going into Chinese ports, where at this present time 6% of the world's bulk tonnage are currently sitting off the Chinese ports, and where we have freight rates that are going up and up and up, and bunker pricing becoming an increasingly smaller element to the freight cost. And so there may well be compelling economic reasons why a charterer would want to delay, but when one's talking about very, very, very high rates of demurrage, there is a human and economic imperative to get the cargo in and out and off as quickly as possible. And if that means getting in the queue earlier, then that's fine. It will only ever work when the system will work in its entirety. The ports will be able to give you an absolute definitive time for when you would be able to berth and stick to that. And until we get the entire infrastructure working in the right way, one can see economic reasons militating against the use of this clause. It is a well-drafted clause, but there are also some substantial legal questions and areas for dispute. And as I mentioned, the best endeavours, it is a high burden, but whenever one talks about best endeavours, there are also arguments about what qualifies as best endeavours. We are talking about how one actually compensates, and where you're talking about quite substantial sums of demurrage, very quickly there are going to be quite large disputes on the delay time. So does the system, which essentially kicks it back to the parties to figure it out for themselves, is that going to work, or are we going to just have dispute after dispute after dispute? And is a charterer going to enact that his rights to have a just-in-time approach voyage or a laden voyage if he doesn't know who's holding the bills of lading and he doesn't know whether they're going to be bound into any agreement within the voyage charter? And Simon's telling me to be quiet, so I shall wrap this up.
Be quiet.
The reasons to be optimistic. The future is green. We live in a world of green shipping. It's only going in one direction. And the just-in-time clause should be seen as nothing more than part of the green shipping initiative. Carbon is in the sights of everyone within the IMO. is front and centre. The amendments in MEP 76 to the Marple Annex 6 all dealt with energy efficiency and carbon intensity of vessels. And on 1st of January 2023, we're entering into a new carbon low environment. And there is a pressure upon all ship owners to deliver a low carbon solutions and all stakeholders to deliver a low carbon solution. And the Sea Cargo Charter, which has been signed by the who's who of the chartering market across most of the major grain traders and oil traders, and really a who's who of chartering, have given the mission statement that to ensure that charterers have the information necessary for them to calculate the emissions that result from their chartering activities and subsequently assess how their overall emission profile is developing in comparison to the requirements of the IMO's initial strategy on reduction of greenhouse gas emissions from ships. And then they set out a clause that has to appear in their voyage charters, which requires the owners to report. And you can see by the obligation to report on the emissions of ships tied into the energy efficiency and carbon intensity of vessels initiatives that are being run by BIMCO and IMO as well. You can see that ship owners that don't buy into the low carbon green shipping and start to embrace just-in-time travel may well be seen as outliers in the market. That's all.
Thank you very much, Andy. Now I'm going to hand over to Peter Stevenson, who's going to talk to us about the BIMCO COVID-19 crew change clause for time charter parties, last year's addition to the BIMCO suite of clauses.
It says it's last year's clause, and it was introduced at a time to deal with difficulties that had emerged early on in the pandemic, namely ports around the world refusing to allow crews to embark or disembark, making crew changes very difficult to arrange, and leaving crews stranded for very long periods of time on board. The clause was intended for use on longer-term time charters, as entitles owners to deviate from their charter's employment orders to ensure that crew changes could be completed and the crews relieved. Now I'm going to look at the clause and go through it and consider how it fares a year on, or more than a year on, where the situation is somewhat different and COVID is becoming endemic in large parts of the world, but not in others, with ports more willing to allow crew changes, albeit under stringent restrictions, but some states, particularly in the Far East, continuing to impose very strict restrictions on vessels that have recently conducted crew changes, which can result in very significant delays. The principal part of the clause is in part A, and it provides that in addition to any other right to deviate under the contract, the vessel shall have liberty to deviate for crew changes if COVID-19 related restrictions prevent crew changes from being conducted at the ports or places to which the vessel has been ordered or within the scheduled period of call. And the key word there is prevent. The explanatory notes published by BIMCO at the time said that that was a high threshold, and the fact that crew changes are more expensive or less convenient would not engage the clause. When it was drafted, that may well have been meant the clause had some wide application. As I said, ports were refusing to allow people to crew changes to be effected. It is less clear how widely that will apply now, because crew changes are now possible, albeit under difficult scenarios. Does that render the clause ineffective? Not necessarily. As I said, while crew changes are now possible at ports, they, in my experience, result often in quite significant delays at the intended port while paperwork's checked and further tests are done. I suspect that if you can show that the crew change is likely to take a very long period of time, or a period of time which is significantly longer than one would anticipate, tribunals would be sympathetic to the idea that it has been prevented from occurring within the scheduled period of call as specified in Part A of the clause. Now that's not certain, and if you want certainty in terms of allowing crew changes at ports other than those to which vessels have been ordered, you would need to change the clause and reduce the nature of the trigger, or the requirements for the trigger. Now, if your clause is engaged, the deviation will not be a breach of the charter party. And in practice, that means the decision to deviate to a port other than to the one you've been ordered will not constitute a breach of the employment clause in the Charter. And it follows, it says in the clause, that owners shall not be liable for any loss or damage resulting therefrom. Now, that's an important point, and I'm going to park it, because what I'm going to come to at the end is what are the consequences of crew changes and whether they are caught by the provision. Moving on to Part B. B is quite straightforward. It simply says that the owners will exercise their rights under subclause A with regard to the Charter's interests and shall notify Charters in writing. Using Simon's analogy, I think that's a fig leaf given over to the Charters. It doesn't really mean anything in any sense. Part C, though, is significant. Part C imposes an obligation on Charterers to procure that subclause A shall be incorporated into any and all sub-charter parties, and more importantly, bills of lading, way bills, or other documents evidencing contracts of carriage issued pursuant to this charter party. Now, that may be difficult for a charter to achieve. The clause is designed for to be included in long-term time charters, and voyage charterers will be resistant to a clause which entitles that level of deviation. That has significant consequences. If a right to deviate for a crew change isn't incorporated into a bill of lading contract, a deviation could in principle deprive the carrier from relying on the exclusions and limitations of liability that it might otherwise be entitled to rely upon, and it could expose it to significant additional loss. So this clause, or Part C of it, would, it seems, entitle those losses to be recovered from the charterer for failing to procure the right to deviate its inclusion in the bill of lading contract. Now, how significant that risk is not easy to speculate about. One would argue that if a crew change is necessary and it can't be done at the ports to which you're ordered, it may be a justifiable deviation or a reasonable one using the Hague Rules test, and therefore the consequences of, well, there won't be a deviation. But I think it's important to highlight the risk to charterers, and if charterers consider, time charterers, that it will be difficult to incorporate this clause, they would need to reconsider that part of the provision and maybe change it from an absolute obligation to some form of alternative obligation, water it down effectively. Part D of the clause sets out the economic consequences of the deviation. It really is a matter of negotiation, but the point to note is that the default position is that hire will be payable at a rate of 50-50 during the period of the deviation, as if an alternative isn't agreed. And then Part E of the clause really just says that owners will bear the costs of the crew change, which is not unexpected. So where does that leave the parties? The clause provides a neat regime for dealing with the problems of ports refusing to allow crew changes, and provides owners with a mechanism for ensuring they can replace their crew. But that's not, in my experience now, the real issue that is facing parties. The real issue we face, and I have 5 or so cases at the moment, and I've spoken to colleagues of all facing a lot of cases at the moment, is where vessels are being detained, principally in China, following crew changes, where it's not clear why they're being detained. It appears principally that it's been done because there has been a crew change per se. And now that arises in a number of different contexts. The first is where a member of the boarding crew is found to have COVID. Now, that doesn't raise that many complicated problems under normal NYP form charter. If the crew member is infected and the crew are isolating as a consequence, the vessel will probably be off hire under the normal off hire provisions, and the crew change clause doesn't alter that analysis. Second scenario is different, where there's no suspicion of COVID on board, there's been a crew change, that all the protocols have been followed, there's been no positive tests during the crew change process, but the vessel is detained simply because there has been a crew change in the 14 days before arrival at the discharge port. Now, absent the BIMCO COVID crew change clause, it might be said that any additional delay caused by the crew change is a consequence of the breach of the employment orders. You'd say that there's been a deviation from the contractual route, not the orders, the vessel, that's in breach of clause 8, and the consequences flow. That argument will not be available if the clause has been triggered, for the reasons we gave in part A. Now, the more complicated scenario is where there isn't any infection on board the vessel, but something has happened during the crew change process which has given rise to suspicions that there could have been. Now, the ones I've seen has been where a member of crew has tested positive prior to going on board and has not gone on board, but the rest of the port to which the vessel arrives isn't particularly interested in the whys and wherefores, sees a positive test and says, well, I need to put you to anchorage somewhere. Alternatively, there's been someone who's tested positive, has quarantined and then joined. But again, the owner may say, well, I've done everything right, the crew do not have COVID, but the port says, well, I have suspicions and I don't want to take that risk. Under normal circumstances, the vessel may be off hire in those circumstances. You'll all have been taken to the Laconian Confidence and the Apollo over the last year and a half, and the discussions in those cases about when a vessel will be off hire due to reasonable suspicions, but it's quite arguable that you will be off hire in those circumstances. And the question is whether the Part A of the BIMCO COVID crew change clause changes that. My answer is it probably doesn't. While the clause prevents owners from being held liable for loss and damage resulting from deviation, it doesn't alter the off-hire regime. And it follows that even if an owner has done everything right in effecting a crew change and has followed all protocols to ensure that his crew are not infected, he may well face significant loss while the vessel is refused entry to its next port. Now, if the owner wants to protect themselves from that scenario, they'll need to make alternative provisions. So in conclusion, the clause was drafted at a time of crisis to deal with a set of scenarios which do not necessarily exist at the moment. The real issue, I say, or I think, facing owners is what happens in the event of a not necessarily easily justifiable detention, and that will need to be addressed by alternative provisions. And it's that, I think, that BIMCO is looking at now with the infectious diseases clause, and hopefully we'll see where they arrive at soon. Well, the clause says nothing about it, nor did the explanatory notes. It will obviously cover the former situation. The latter situation would, in any event, be, you'd expect, be covered by the right to deviate for to save lives or to protect the safety of the crew or vessel. In short, I don't think that situation is covered by the crew change clause, but that would be a point to consider. What do you think?
If the sick crew member has COVID, which means at that particular port you're not entitled to remove them at that port and you have to deviate for that purpose, then I wondered whether the clause might bite in those circumstances.
But, well, again, that would, if you couldn't take the person off the vessel at that port and you had to go elsewhere, it would nonetheless be justified, you'd be entitled to do that in any event, with the clause or not, I would have thought.
Does the BIMCO explanatory notes, not often very helpful in my experience, but do the BIMCO explanatory notes indicate that this is a wholesale crew change or any crew member?
It doesn't provide any...
So there's plenty to argue about what crew change.
Yes, quite.
Okay, Andy, questions come in for you, and if I may, I'm just going to flick back so that we can see the clause in question, looking at subclause C. So this is the entitlement to owners for additional time, where you've got extra time used as a direct consequence of the charterer's request. Now the question that's come in is, what about the situation where the vessel ends up arriving late as a consequence of being asked to slow steam? So let's say there's slow steaming, and then by the time they get to the port, at the time they've been arrived, there is, or something else happens in the way. So in terms of causation, how does this clause operate? It assumes, like you said, a nice, easy circumstance in which everything ticks along as it's supposed to. But what if bumps get in the road?
Well, the whole concept of just-in-time envisages that if there is best endeavours communication of the time frame, then there shouldn't be a bump in the road because the vessel should arrive and go straight into a berth. That's the panacea that people are trying to achieve. And so if during the time when she may have arrived and when she actually did arrive, a ship sinks at the berth and shuts the port down, or the port is shut down for any other reason, then I don't think that would have any material impact, because the fact is the vessel would, whether the vessel would have arrived a week before, she wouldn't have berthed by that stage, therefore she would be on demurrage, and if she arrives late, then one would still factor in that elongated time as demurrage time that the charter would have to pay by way of damages under this clause.
In one sense, it's a BIMCO intervention. It's a BIMCO intervention, really, to make life a little bit easier for owners, and therefore a charter has to show not knowingly operated, that he knowingly operated it other than in accordance with the SOLAS guidelines. The SOLAS guidelines, the IMO regulation 1106/29, says if the master believes that the continual operation of AIS might compromise the safety or security of his or her ship, or where security incidents are imminent, the AIS may be switched off. Okay, well, the master must reasonably believe that he's actually facing a safety or a security incident that requires AIS to be turned off. As I've said, it's quite difficult to envisage what some of those are, except piracy. And that's the example that's usually given. But it is very, very difficult for a charterer. Let's assume there have been 3 incidents where AIS has gone off. They've asked under Clause C, what's the explanation? Oh, sorry, defect, or sorry, I've turned off by accident. That's the explanation. Like it or lump it. In those circumstances, the charterers may be facing a real risk that OFAC or some sanctions body doesn't like that explanation, or just decides that there's something odd about this vessel and decides to list it or designate the owners, and the charterers have very little solution. That is why I think the ad hoc clauses may still have a role to play. I mean, the beauty of BIMCO clauses is they make us think about these things. If a clause said, if there are more than 2 incidents of AIS being turned off or in any way being operational, the charter shall have a right to cancel. That, it seems to me to be a different allocation of risk. So I think these clauses are good, but obviously B and C are the start of an LMA arbitration, because as soon as you say you have knowingly operated it, they will say no, we haven't, and then you can't terminate unless you decide to jump in the dark. Sometimes one can get a bit over dramatic about this, because the AIS cases I've had, the AIS agencies that carry out reports for owners and charterers, some of the examples, they're literally impossible to explain. The vessel starts here and ends up over there, or starts here and then 3 days later it's still there, even though there's a little blip because someone failed to turn it off over here, or there are oddities. And so I think it all depends on the facts, but there is an argument to be had there about whether it's owner's balance or charterer's balance. I think it then would just be the ordinary law that you exercise your right within a reasonable time. Obviously, you're waiving your right to terminate if you say, okay, well, I've heard your explanation, and now perform this service, now do this, now do that, now I'm going to terminate. If the charter say your AIS has been turned off for 3 days, you're nowhere near a piracy area, what on earth are you doing? Owners come back with an explanation saying, I'm sorry, he bumped it and turned it off by accident, and the freight rate is falling. The charterers may say, I'm not really going to wear that explanation, but that's the risk. And that's why I think BIMCO put in knowingly operated, because otherwise the old clauses really were, yippee, freight rate's moving, AIS was turned off for an hour, I'm off.
I've certainly seen emissions clauses in many time charter parties which recognise the green shipping, recognise the need to recognise the right to slow steam. But ultimately, I mean, it's the charterer's decision. It's his asset he's operating, and as long as his employment orders are valid, then there is an obligation under the speed and performance warranties to proceed in accordance with the charterer's orders. Whether the clauses on emissions cut through that and permit the owners to slow steam, I've seen some, but not many. Absolutely. I mean, this clause is only about voice charters, but is part of a much bigger green initiative. And, you know, we are going to have slow steaming for green reasons, and it's the future.
Well, I think that's an excellent question. At the moment, it is unclear. It doesn't have the same wording that, for example, is in Andy's just-in-time clause, which says notwithstanding anything else anywhere. So there's no suggestion that it trumps necessarily any other clauses. But one can see an argument as a matter of construction that in circumstances where the parties have chosen to include this clause dealing specifically with obligations to have adequate cybersecurity measures in place, that there would be a good argument to say, well, even if there is a breach of some other obligation, for example, the obligation of seaworthiness, the parties have specifically decided that this is how the issue ought to be dealt with. I heard a murmur of discontent from my right. Simon, do you have a different view?
I find that a difficult argument. It says a breach or series of breaches of this clause. It's rather like the demarriage debate about whether you're in breach of the LACAN or you can found some other breach of some other obligation. I would have thought that if you want to make sure the limit is applicable to seaworthiness or something which is an entirely separate breach of an entirely separate provision, you need to make that clear.
Well, I agree that there could be more clarity, but I think in circumstances where what is required is specifically quite extensive obligations in terms of cybersecurity measures and systems, then one does have an argument that this is how the parties have chosen to cater for the obligations of cybersecurity.
But if you've incorporated a clause paramount saying the vessel should be seaworthy under Article 3, Rule 1, and that's a freestanding obligation which doesn't operate with this. You can say, well, I'm sorry, I'm not relying upon A, I'm relying upon Article 3, Rule 1. No prudent owner would send his ship to sea in this state with your computer in the state it was without having been updated for 2 years or whatever it is. The computer's defective, your systems are defective. It's nothing to do with this clause. I can see that, but I would have thought that they're entitled to say, your defective system has amounted to a breach of 2 separate obligations. One obligation is the cybersecurity clause, the other obligation is Article 3, Rule 1. You haven't limited your liability for Article 3, Rule 1. I'm entitled to put my claim under Article 3, Rule 1. I'm not relying upon the cybersecurity clause. This clause says a breach or series of breaches of this clause. I do not, in my points of claim, allege a breach of this clause. I could have done, but I'm not choosing not to. Don't need to. I'm not alleging a breach of the cybersecurity clause. I mean, I see the argument. I mean, the arbitrators think, well, this is a bit rich. You've included this clause specifically to deal with this and put a limit in. But it just shows that all it needs is just a tiny amendment to that, and then you're safe. I mean, obviously, the intention of putting this in is anything covered by cybersecurity, you limit your liability because the risks are enormous and open-ended. So perhaps chartering brokers should just think, let's make a little amendment. Well, whether they ever think about it, I agree, but that's the problem with BIMCO clauses. You import them without actually thinking what it says.
Well, I think it's tempting to take a vote on what people think is the correct construction at the moment, but I think we can probably all agree that an addition to the clause would be beneficial. Unless there are any more questions, then I'm going to draw an end to the Q&A session and hand over to Simon to make some concluding remarks.
Thank you very much. I think very nice to join our hands together to show our appreciation of speakers. We haven't been able to do this for 18 months, so it feels really old-fashioned. Would you mind joining me in a round of applause for the speakers?